Good morning, sir. You're Tristan Calhoun.
Yes, ma'am.
And Mr. Calhoun was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1216 and 1217. I've received the pre-sentence report as well as it looks like two memos from probation that were follow-ups to that report. Have you all had an opportunity to review all of that?
Yes, Your Honor. I have, Judge.
Are there any additions or corrections to that pre-sentence report?
The only correction we had was under the substance abuse history. I believe they their alcohol data birth usage, it should have been 18, 19 years old, not 8 or 9 years old.
Oh, okay.
Yes, ma'am, but that was the only correction.
Okay. Thank you. Anything?
Judge, I would just like the record to reflect that my office made multiple attempts via a regular victim contact letter with both of the complainants in these cases in order to try to obtain a restitution amount via that letter, via a restitution request form. I then was able to work with Miss Roach, who did some investigation on it, and we have an investigator to find different numbers for those young ladies. They were able to reach out to them and have them call to the probation department as of this time, unless it's somewhere in the paper sphere. I don't have a restitution amount from them. I understand their concerns that they voiced, but I believe that the offer was appropriate based upon his lack of criminal history and the severity with which the court can punish him on any type of revocation. I don't know how Your Honor would feel about ISF based on his age, but I would suggest maybe at least considering the positive track of ISF.
And Your Honor, I have spoken with Mr. Calhoun in regards. I told him there could be restitution in the future if anything is provided.
Well, if it's not ordered today, there will not be any. And
Okay.
So that's why they attempt to get all that information. And it sounds like the district attorney's office and the probation office has made a diligent attempt to try to get any number. And so there's no coming back later for restitution. So we'll just have to go forward without that. Mr. Calhoun, I'm going to find in each of your cases that you entered pleas of guilty freely and voluntarily. And in cause number 25, DCCR 1216, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 7 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll go over some of those in just a few minutes. And then in cause number 25, DCCR 1217, also find sufficient evidence to find you guilty. However, I'm going to follow that agreement and defer all proceedings and place you on probation for 7 years. You'll be ordered to pay a $500 fine in that case as well and to follow all of the rules and conditions of probation. I am going to order that you enter and successfully complete the JCDI program. It's an outpatient treatment program. That's what was recommended after that substance abuse assessment was done. I'm not going to order any further upfront or ISF. I think you're 28 or 29.
28.
Okay. This seems very, very out of character for you. And this was a terrible day, and what you did was terrible and affects at least one of these ladies had some significant issues and probably will forever based on this. But I mean, you have no criminal history, and so we're going to get you the help you need, and hopefully you can be successful on probation and not have any issues. So what that means is you don't have felony convictions on your record right now. And if you successfully complete these probations at the end, the case will be dismissed, both of them. You'll never have a felony conviction. So it's a great opportunity that you're getting today.
Yes.
The other side of that, and part of what Ms. Molfino was stating, is that if you violate any condition of your probation, you can be brought back into court, and then I could find you guilty of both of the offenses and sentence you to prison for between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
So I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you have waived your right to appeal. Probation will talk to you before you leave the courtroom today. It's very important that the first thing you do when you are released is go to the probation office and make sure you get everything started and lined up with them.
Yes, ma'am.
All right. Yes, ma'am.
Sorry, just if I may, so
Take
the
these.
record reflects and in the instance that anybody is observing. Of course, I would not hesitate at all to put those victims in contact with victims assistance for on victims compensation.
Yeah.
Based on these pleas, I think that would be an avenue that we can travel down, and that I don't want this to obstruct that, but I understand the restitution amount. I did not have support today.
Sure, and there are definitely some avenues, if they get in touch with the district attorney's office that might could help them, with some of that. Okay, thank you, Ms. Malfino. You can go back with the bailiff.
Thank you.
Yes.
Thank you.
All right, careful.
Thanks. Okay, are you James Watt? You're James Gwatney?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Gwatney, in clause number 25 DCCR 0736, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. And that's from March 5th of 2025. And how do you plead to that charge?
I guess guilty.
Well, there's no I guess. Either you did it or didn't do it. So are you guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily? Answer out loud, please.
Yes.
Did anybody force you to plead guilty today?
No.
Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gwatney is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're
And just like that, he's found guilty 2 years locked in. No appeal. The judge double-checks he's competent in pleading voluntarily. This is standard, but it's a reminder. Waiving your rights isn't just paperwork, it can change your life forever. Did he really understand what he gave up?
mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written
Heads up because of this judgment. He can't legally possess guns or ammo in Texas. Seems minor, but breaking this law can land you in serious trouble. Fun fact, these restrictions can last decades. Ever wonder how many people? Fully grasp that before pleading guilty interview.
admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Can I ask you one question?
Sure.
Whenever I was brought back from Oklahoma, I had 6 months left on my 3-year sentence. They sentenced me to ISF until discharge. Why was this charge that is being brought up on me now not brought up on?
Here's where the system's timing gets messy. Charges filed months ago, but only now addressed, leaving him baffled. Court timelines often don't match reality. Imagine learning about a charge months after it technically applied.
Me while I was being incarcerated back in ISF for the last 6 months.
How would you think I would know that information? I have
Huh?
no idea. I have no idea. I
I have gone over the time frame with him. From what he told me, the time frame that he was in ISF was after this case was filed.
yeah,
Case has been indicted over 6 months.
yeah.
Yeah, and
I don't
he-
know. I don't know why that didn't happen, sir. I'm not sure if it was
The
something.
charges were supposedly filed in June of 24. And I was arrested in 25.
These charges are from March of 2025, sir. And you
25.
just pled guilty to that and it's done. You got your 2 years. You can go back with the bailiff, okay?
Okay.
I don't know the answers to those questions. Mm-mm. I'm still. It is. I just missed my note. On camera.